watching UNO with Dr. Ambrish Saxena.
Hello students, today is Friday 27th of September 2019. Today we will try to unfold few more stories, and to begin with we will talk about the problem or the crime of rape in India. And this is a crime which has always been in the rise even in 21st century, despite whatever changes are happening in law, in society, but the crime is on the rise. But legally there are more and more stringent laws are being made to put a check on this kind of crime. And if we refer to one day old story, Delhi High Court issued administrative orders that whenever the bail application of a rape accused is to be taken into consideration by the trial court or by the High Court, then the consent of the rape victim or rape survivor has to be taken into account. And as per the administrative order of Delhi High Court, they have added a pro forma which the prosecution has to add with the bail application. In this pro forma, the consent of the victim is to be taken and the victim has to be informed by the prosecution that such and such bail application has been mooted, because earlier a lot of such cases have happened where the victim is completely not aware that the accused has been granted bail. So this is definitely an attempt to plug a loophole which has been there in the system, and this in fact has originated from an amendment in the criminal law of the country, which is an amendment in CRPC, and as per section 439 of CRPC, this has become mandatory that the rape victim's consent has to be taken in any case. So this is really a welcome sign. But if we look into the progress, though very little time has passed since the time this amendment was made, but close to 1 year, if we look into as to what progress has been made during this period, then we find this is very dismal, because the role of the investigating officer means the police sub-inspector or the inspector who is investigating the case, and the prosecution means the public prosecutor, the lawyer who is fighting the case in the court on behalf of the state. Their role has been very dubious in many cases, and despite all these changes, they are not performing the role which they are expected to perform. Now, coming to another important story, which is again from the legal arena. The story is about the transfer of a few judges of the High Court and the Chief Justice of High Court. If we look into the system as to what whole system is about the appointment and transfer of judges. Now, as per the system existing in India, there is a collegium system. Collegium system means in the Supreme Court, the Chief Justice of India and 4 senior most judges, these 5 judges form the collegium, and they take all important decisions about the appointment and transfers. Transfers means from one High Court to another, and also the elevation from High Court to the Supreme Court. And this is a very strange system in the sense that judges are making the appointments of judges. It's the same thing as the legislators or the parliamentarians taking decision about hike their own salaries. So, if we see as to how effective this collegium system is and whether there is a way out or where there is an option, a better option to this kind of system, then also I can refer to some attempts made in this direction. In the year 2014, Parliament brought a law in this area which was titled as National Judicial Appointment Commission Bill. So later it became an act. This bill was passed by both houses of Parliament in 2014, and mind it, this is the bill which was the first bill which was taken up by Parliament in 2000, the newly elected Parliament in 2014. Before that also in UPA 2 also this attempt was made, but that government failed to ensure that it sails through Parliament, but the new government of Narendra Modi in 2014 succeeded in doing that. So it was almost unanimously passed by both houses of Parliament, and thereafter, as it is mandated under the Constitution, 16 states also gave the consent to this bill, to this act, and then this act got the presidential assent. In December 2014, the president gave his assent, and in April 2015, National Judicial Appointment Commission was set up, but this was challenged in the Supreme Court, and Supreme Court held this unconstitutional. So the whole system again turned down, and then the old system of collegium took place. The two most recent cases, if I tell you, the Chief Justice of Madras High Court, Justice Tahil Ramani, she was transferred to a High Court wherein only 4 judges are there. So that is the Meghalaya High Court, and mind it, she was the senior most Chief Justices in the country. She would have been about 1 year more on her current position, the Chief Justice of Madras High Court, which has 75 judges on its strength, and thereafter there was a possibility of her elevation to the Supreme Court. But once the transfer orders were issued by the collegium, she made a request for reconsideration, but even after that the collegium did not change its stand, and thereafter she resigned. If we look into the profile of Justice Tahil Ramani, which is loaded on the website of the High Court, then we find that she disposed of the Bilkis Bano case of Gujarat, referred to the 2002 Gujarat riots, where she was a judge in Bombay High Court, and the case on the direction of the Supreme Court was shifted from Gujarat to Bombay. Another case is that of the Justice Akhil Qureshi, who was a judge in Gujarat High Court. For a while he was also made the acting Chief Justice of Gujarat High Court. Last November he was shifted to Bombay High Court. Now his elevation was due as the Chief Justice of Madhya Pradesh, but the recommendation in this regard made by the collegium was sent back by the government for reconsideration, and then the collegium reconsidered and sent him to Tripura High Court. And mind it, there is a story linked to Justice Akhil Qureshi also. While he was a judge in Gujarat High Court, he disposed of a case related to Sohrabuddin encounter in 2010, because of which Amit Shah had to be sent to police custody. So that is how there are question marks on this collegium system and the transfer of judges, whether it should be treated as a punishment or whether some more powers or more caliber is required to work in the big High Court like Madras High Court or the Madhya Pradesh High Court, or what should be the way out. Justice Chandrachud of the Supreme Court has spoken on this, and he said that there has to be something in between the impeachment and the transfer. So this is something which we have to thought of if we want to see that our legal and the judicial system reforms. That is all in this today's edition.